right, we're going live. I love often the duty of care, failure to act. A duty imposed with regard to risk that arise within the scope of the relationship. A duty may arise based on the degree of knowledge of or foresight of the risks, and that is a quote or derives from Commonwealth versus Peterson. So duty is opposed with regard to risks that arise within the scope of a relationship. A duty may arise based on the degree of knowledge or foresight of the risks. Commonwealth versus Peterson. I might just navigate over to that case if I can find it. May very well just not be findable because I've gone through quite a few pages here and I'm not finding that case. So, the next point is the duty to rescue. There is no duty to rescue from L.S. Ayers and Company versus Hicks. Duty to rescue, a duty to take positive or affirmative steps. However, a duty to rescue may be owed where the defendant controls the instrumentality causing the injury. Professional's duty to exercise reasonable care to protect third persons will subsist once a therapist in fact determines or should have determined that a patient poses a serious danger of violence to those third persons. And this is Tarasov, Regents of U of C. And this case comes up a lot, actually. Like every single physician knows about this case. And every time I come into contact with one, they talk about it. So I also found the Ayers and Company, which is about rescuers. So let's just read. Okay, and I found Tarasov too, which is about physicians or professionals. So what I have highlighted in L.S. Ayers and Company versus Hicks is there's a legal obligation to take positive or affirmative steps to effect the rescue of a person who is helpless or in a situation of peril when the one proceeded against is a master or inviter, or when the injury resulted from use of an instrumentality under the control by the defendant. Such obligation may exist although accident or original injury was caused by negligence of plaintiff or through a third person. What does that mean? It means that this is the escalator case. So this is an escalator case, but I mean, what they're meaning to say is like if you put that person at peril, then it's your duty to rescue them. Also, if you began a rescue, you can't just you have to carry it out. You can't just abandon a rescue. That's what like that last part means. But this particular case is actually the escalator case, like somebody got stuck in an escalator. All right. Tarasov versus Regents. The professional's duty to exercise reasonable care to protect third persons will subsist once a therapist in fact determines or should have determined that a patient poses a serious danger of violence to third person. So here's the Tarasov case. As a general rule, one person owed no duty to control the conduct of another, nor to warn those endangered by such conduct, except when defendant stands in some special relationship to either person whose conduct needs to be controlled or foreseeable victim. Excuse me. I wonder if I should write that down. One person owed no duty to control the conduct of another. And then it said, except due to special relationship to either person whose conduct needs to be controlled or foreseeable victim. So there's one last point here. There's a duty to protect third parties against serious dangers of which one is special knowledge threatened by those for whom one bears some special responsibility. So that's just saying everything in another fashion. So negligent infliction of emotional stress is what's on the next page. Defendant may be found liable for negligent infliction of emotional distress in Daly v. LaCroix. Here, court uses the physical manifestation test, replacing the physical impact test. Plaintiffs are exposed to the risk of physical injury. Bright line test for negligent infliction of emotional distress. Damages for, in this cites Thing versus La Chusa, and damages for emotional distress are recoverable if and only if the plaintiff establishes a close familiar relationship, plaintiff is present at scene and aware it is causing injury, that's the zone of danger, and plaintiff as a result suffers serious emotional distress beyond that of disinterested witnesses and which is not abnormal. So going to where these cases are and have been briefed, we have LaCroix. This one was a power line impacted by car accident created an explosion and considerable property damage. Additionally, plaintiff claimed that Estelle Daly suffered traumatic neurosis, emotional distress, nervous upsetness. Timothy Daly, I believe that this affected their home. And they reversed and remanded, and the claim being dismissed. Okay, so they thought they wanted to hear it. So in the analysis, it upheld common law for a long time to prevent imaginary claims, but other jurisdictions are adopting the premise that sufficient evidence presented by plaintiff must be shown to create a burden of proof for the jury to decide. I think that's what I mean. There's another case about negligent infliction of emotional distress, and that's Thing versus La Chusa. So mother plaintiff told by daughter about motor vehicle hitting her son nearby. And so that's not close enough. So the bright line test I have highlighted, it looks like it's kind of long, but it's from the Amaya case on impact rule in the zone of danger. In the previous Dillon case, was abandoned, but a bystander versus direct victim analysis available includes foreseeability and a relationship between the plaintiff and the victim. So that's interesting. Zone of danger was abandoned for bystander and direct victim. Yeah, that is the bright line test right here. Okay. So the zone of danger came from a power line explosion to house. The bright line test is, well, the zone of danger is referenced here in the next case, but the bright line test, I thought, abandon that for the bystander and direct victim analysis, or at least that's the bright line test now involves. I'm just like making stuff up. I don't usually read these outlines and go back to the case. Outside of premises. Okay, so the duty of care, ownership of owners of land. A landowner must exercise reasonable care under the circumstances in maintaining his or her property, from Taylor versus Olson. Let's just stop there because I know it's here. Taylor versus Olson was a plaintiff driving car down a 2-lane blacktop highway. Frequently, about 90 motor vehicles went down this a day, and the driver was struck by a roadside tree, sustaining injuries. The tree had shortly before splintered and fallen across the road. Property forested because the purpose of purchasing it was for logging and had been logging nearby the tree in question 5 to 6 weeks prior to the incident. However, the defendant would not have noticed the tree's condition was unsafe because it was rotting on the inside only, and reasonable care was visited here to prevent an unreasonable risk of harm, extend responsibilities to inspect or act on actual knowledge of potential danger. Right, so in Taylor vs. Olson, a tree fell on a driver, and landowner must exercise reasonable care in the circumstances in maintaining his or her property, right? Act on actual knowledge of risk of harm. To reduce like unreasonable risk of harm. So balancing factors tests include location, use of property, and customary practice in engaging reasonableness. Breach is determined by notice of the risks in the conduct and the precautions necessary to protect the public. And they point to Sullivan versus Wilmington Park. This is a baseball getting hitting somebody walking by. because they don't have a high enough screen or whatever. So, and clearly they could have taken better precautions, so probably the park is liable. Duty of care owners of land, types of duties to trespassers. For an unknown trespasser, a landowner does not owe a duty to protect an unknown trespasser. For known trespassers, the landowner owes a duty to a known trespasser to use reasonable care to avoid injuring the trespasser through active operations. This is changing to a more flexible approach to determining liability, the balancing test. Tolerated intruders. Defendant's continued toleration of a trespasser amounts to permission to enter the land, so the plaintiff becomes a licensee. And dangerous conditions known to the owner. There's notes. It keeps referring to notes. So where are these notes at? I guess we don't have them. See notes, page 508 to 10. All right, so this is a look at the book, but I don't have the book anymore. At least not here. Duties to invitees and licensees are a little different. I mean, before you get too messed up, if you don't know a trespasser's there, you don't owe them a duty. If you know they're there, you can't, you have to use reasonable care to avoid injuring them through active operations. And for tolerated intruders, you treat them as licensees. Dangerous conditions known to the owner, I'm pretty sure that means you need to warn. And one to whom a license is granted, someone who has official permission to do something, someone who has permission to enter or use another's premises, but only for one's own purposes and not for the occupier's benefit. The occupier has a duty to warn the licensee of any dangerous conditions known to the occupier, but unknown to the licensee. An example of a licensee is a social guest from Black's Law Dictionary. An invitee is a person who goes into the land in furtherance of the owner's business. The owner has a greater duty of care towards the invitee than a licensee. The owner of land has a duty to exercise reasonable care in keeping the premises safe for use by the invitee. So that includes inspection. For a social guest, this is a licensee who enters the premises of the owner by permission, but for the licensee's own purposes. He goes onto the other person's property for companionship, diversion, or entertainment. A social guest must take the host premises as he finds them. However, the owner has a duty to warn the licensee of any hidden dangers which are unknown to the guest and which the owner has knowledge, and to refrain from injuring his guests willfully or wantonly. All right, so licensees pretty much are social guests. Invitees are like customers. And so you do have to inspect if you're inviting customers on your property, basically. That's how I like to think of it. Now, a licensee / social guest, you have to warn them of hidden dangers, but otherwise, they kind of come at their own risk. Landowner duty to children. Landowners have a higher duty of care to children. Restatement Torts, Second Torts 339. Attractive nuisance. Artificial conditions highly dangerous to trespassing children. A possessor of land is subject to liability for physical harm to children trespassing thereon caused by an artificial condition upon the land if A, the place where the condition exists is one upon which the possessor knows or has reason to know that children are likely to trespass, and B, the condition is one which the possessor knows or has reason to know and which he realizes or should realize will involve an unreasonable risk of death or serious bodily injury to such children, and C, the children, because of their youth, do not discover the condition or realize the risk involved in intermeddling with it or in coming within the area made dangerous by it, and D, the utility to the possessor of maintaining the condition and the burden of eliminating the danger are slight as compared with the risk to children involved, and E, the possessor fails to exercise reasonable care to eliminate the danger or otherwise to protect the children. So this is the case. I feel like this is a learned hand decision, but the case name I can't exactly remember. I know that it was near Carol's Towing, but it's not Carol's Towing. I actually wrote all this down, so in an earlier recording. So let me just find it. Because, like, now I'm curious. Like, I feel like I need to know this case. I mean, I don't, but I feel like I do. There's a risk utility balancing from U.S. Towing, but it was not Cray & Bowl. Okay, Carroll Towing is the source of Learned Hand's risk utility balancing, but it was Cray & Bowl or Pfeiffer or Blythe. I've written down all of these facts, or all of these factors in the section called Landowner Duty to Children. Obviously, the place is an attractive nuisance. The condition involves unreasonable risk to children. Children are totally attracted to it and don't recognize the risk. And the utility of maintaining the condition and the burden of eliminating the danger are slight compared to the risk, and yet the possessor fails to exercise reasonable care to eliminate it. Invitees and licensees continue duties to persons entering owner's land. Licensees, it's a duty to warn of a dangerous condition known to the owner. Invitees, it's a duty to protect the entrant against unusual dangers of which owner knew or should have known. On public land, the state, city, or county owes to all persons coming on the premises a duty to use reasonable care to keep the premises safe. And children, landowners have a higher duty of care to children. Duties to lessor and lessee. A landlord has a duty to exercise ordinary care in the maintenance of the premises, and this is Hagelsdorf versus Safeco. Landlord is under a duty of care to take reasonable precautions against such criminal acts. The elements of the duty drawn by analogy from other special relationships like innkeeper-guest set are Klein versus 1500 Mass Ave Apartment Corp. I'm pretty sure that's the corporate. I'm pretty sure that's the case about like safety measures. The landlord's ability to exercise control, the landlord's advantageous position in exercising control and minimizing risk, and the knowledge of the landlord about the risk of criminal behavior. It definitely has to do with security cameras or something. Then you've got the contributory and comparative negligence. For legal effects of plaintiff's negligent behavior, there's pure contributory negligence from Butterfield. Even 1% of actual fault of plaintiff bars the plaintiff's case entirely. 3 states follow this: Virginia, Maryland, and DC. Okay. And places the cost onto one of 2 people at fault and undermines the goals of the tort system. The last clear chance rule from Davies is cited here. If the plaintiff can show that the negligent defendant had the last clear chance to avoid the accident, then plaintiff's contributory negligence will save plaintiff from being barred from recovery. Pure comparative negligence from McIntyre. Jury will apportion amount of liability to each one of the parties. Example 40% and 60%. Modified comparative, that's the 51% rule from McIntyre. Also, plaintiff is more at fault than defendant, then plaintiff case is barred. And Equipoise 50-50 rule. If both negligent, 50% case is barred. So I feel like finding those cases because they're good. Like they really are. But at the same time, I'm trying to find them. Oh, there's Klein. Elements of duty to deter crime. There's the Commonwealth versus Peterson. This was the Virginia Tech shooting. Announcement fails to indicate shooter was at large. Davies versus Mann, last clear chance from donkey accident. McIntyre versus Valentine, that's comparative negligence modified from motor vehicle accident. And what else did I quote there? Was that it? Could have been it. For example, Davies and McIntyre. Butterfield. Oh, Butterfield versus Forrester. Horsefall over highway obstruction establishes pure contributory. What's pure contributory? Oh, is that even if 1% of the plaintiff was at fault, it bars the plaintiff's case entirely. So they're trying to see that maybe the horse shouldn't have fallen because it should have saw the obstruction in the road. Steps to analyze and contributory negligence. Actually, now that I know what these cases are about, I'm going to write them in here. And Davies was at the donkey accident. And then McIntyre was the motor vehicle accident. Now, steps to analyze contributory negligence. Contributory negligence analysis. First, make sure that there is a negligent act. Then see if there is an affirmative defense to see if the defendant's liability is decreased because of contributory negligence by the plaintiff. Next, examine the conduct of the plaintiff to see if all 4 or 5 elements of negligence have been met. In other words, now do a negligence analysis as if the defendant was suing the plaintiff. And if yes, look at what legal impact of the contributory negligence is, and there's 4 types. Assumption of the risk, express or implied. Assumption of the risk requirements. The plaintiff had actual knowledge of the risk. Plaintiff had appreciation of the magnitude of the risk. And plaintiff voluntarily encountered the risk. So, assumption of the risk is expressed and implied. Assumption of the risk requirements. The plaintiff had actual knowledge of the risk. Plaintiff had appreciation of the magnitude of the risk. And plaintiff voluntarily encountered the risk. This is really important because it's like the only way to get out of strict liability or product liability for some of these that are going to come up. So pre-injury release forms. Senior versus National Fitness Institute. You can imagine what that's about. Pre-injury release from liability. Plaintiff's assumption of the risk. Injury through a pre-injury release form. Liability will be enforced if the injury is within the scope of the terms of the release and the release is not in violation of public policy. Implied assumption of the risk. Implied assumption of the risk from Rush versus Commercial Realty Co. In order for there to be implied assumption of the risk, plaintiff's conduct must be voluntary. Plaintiff's actions are not voluntary if plaintiff has no choice. So this was an assumption of the risk as actually don't have much more here about this. But the Senior versus National Fitness one, that was exculpatory language, like in their contract. So this is up around the 450th case brief of the book. So just kind of getting all the way back here. Deluna versus Erie. Peters versus Curry. Riss versus New York. Whoa. Good mood, honey bear. Clark versus Oregon Hell. What's this? Abernathy Sisters of St. Mary's. Zelmer versus Zelmer. So I went too far. This was actually in the 140s. Murphy, 39. Conroe versus Pearson again. Wrongful death liability on part of defendant. And it was, this is a shooting on the campus of Virginia Tech. We're talking about an email breach of duty to warn the Virginia Tech officials for the special relationship that the event was secured without awareness that the shooter was still at large. There's my notes. They shouldn't be there. Here's Putterfield versus Forrester. Sober. Plaintiff fell on horse. Oh, this is the whole assumption of risk, like notes that I took. McIntyre versus Valentine is right here. There's Senior versus National Fitness. Exculpatory clause to be valid specifically indicates the intent to release the defendant from liability for a personal injury caused by the defendant's negligence, and the injuries within the scope of the release. That's exactly what I said earlier. Brush versus Commercial Realty Co. Tenant allowed use of privy, common area of duplex or rental property, stepped on the floor in disrepair and fell 9 feet by way of trap door, needed a ladder to be extricated. Case should have been dismissed as a matter of law. Was there contributory negligence on the part of the plaintiff, or was there an assumption of risk by the plaintiff? This was affirmed for the plaintiff. Right? So, where are we now? In order for there to be implied assumption of the risk, plaintiff's conduct must be voluntary. Plaintiff's actions are not voluntary. Plaintiff has no choice. Plaintiff, did not know there was a 9-foot fall. Assumption of the risk. Assumption of the risk requirements. Plaintiff had no actual knowledge of the risk. Plaintiff had appreciation of the magnitude of the risk, and plaintiff voluntarily encountered the risk. So they had to have actual knowledge of the risk. I don't know what I said a second ago, but assumption, you have to have actual knowledge, appreciation, and voluntarily engage in it. First, an assumption of the risk analysis. Walk the case through the questions from Rush versus Commercial Realty. Example, did Mrs. Rush have actual knowledge of the risk? Yes. Did she appreciate the magnitude of the risk? Maybe. Did she voluntarily encounter the risk? No, it was only privy on the premises. I think by privy they're talking about bathroom. Statutes of limitation and repose. Majority. Time of accrual, discovery doctrine, and traditional minority rule. So the majority follows the time of accrual discovery doctrine. For purposes of statute of limitations, the cause of action accrues when the plaintiff discovered or should have discovered the negligently inflicted injury rather than at the time of the injury. This comes from Teeters versus Curry. which is probably the next page here. No, here. In this case, a plaintiff's physician recommended operation to prevent pregnancy after she bore a healthy child because the plaintiff's edema, anemia, and other complications. She did recover from the surgery, but found she was pregnant and needed obstetrical care and bore a child premature, several complications, and brought a suit 11 months after discovering this, right? Which was 3 years, 5 months, and 9 days after the surgery. Whether the statute of limitation began to run from the date of the injury or from the date of the discovery of the injury. And then you can tell I'll just see if I have the holding. The discovery rule adopted and cited on page 641 and applied to cases prospective, I think, at time of discovery or when it should have been discovered. But the traditional minority rule is that the cause of action accrues with the infliction or occurrence of injury. Mere ignorance or failure to discover the cause of action on the part of the plaintiff does not toll or stop the running of the statute of limitations. Immunity, state and local government. All right, just a couple more, and then we're going to get into strict liability, and we'll call this quits. States have sovereign immunity. Under sovereign immunity clause of the U.S. Constitution, may limit its immunity when it chooses to waive its immunity. Clark v. Oregon Health Sciences. There it is, which is a university. So there's a right to a remedy. That's the only substitute maybe remedy is insufficient for economical reasons to serve justice. So what happened here? A guardian of a disabled infant sought